Good morning, everyone. I'm Chris Parker. This is Kristen Ishihara with the Ishihara Parker Law Firm here in Longview, Texas. And today we're covering a very exciting topic called MERP.
Very important.
Very important.
Very important.
Medicaid Estate Recovery Program, which is MERP, which is a very, very important program for anyone whose loved ones are dealing with Texas Medicaid.
Yep.
Kristen, how does MERP arise? What is MERP?
Sure. So if you have a loved one on Medicaid, and I think kind of the red flag probably for most people needs to be if you have a loved one that's in skilled nursing. If you don't know anything about their finances, you need to check and make sure and see if they're on Medicaid. We have clients that come in that are like, oh, well, my aunt was in the nursing home for 7 years.
Yep.
Well, she was on Medicaid. So you need to know that, because if you have someone that's on Medicaid, you do need to prepare for and plan for what's called Medicaid Estate Recovery Program, which we'll probably refer to as MERP during this video. But what happens is if, let's say, my aunt is on Medicaid and she's receiving benefits while at the skilled nursing facility, my aunt is paying in her copayment, which is probably her Social Security check, but then Medicaid is picking up the difference directly to the facility. So Medicaid is paying $3,000 to $4,000 to $5,000 a month to cover my aunt's care. Well, Medicaid does this because she's met some eligibility requirements, which we've talked about in other videos. But then at my aunt's death, Medicaid Estate Recovery will seek to be paid back from anything that's in my aunt's estate. And so it's very important that you're prepared for that. Chris, talk about logistically. So if my aunt passed away, she'd been in the nursing home for 5 years, what am I expecting upon her death?
Right. So if you're the power of attorney, if you're the person who's been the caretaker, if you're the point of contact, you're going to receive 2 letters in the mail. The first one, it'll have their name at the top. It'll have a notice of intent to file a claim against the estate. It'll say some language like, we're sorry to hear about the passing of your loved one, but the state of Texas has certain rights and obligations, and they need to get paid back for the care they provided. The second letter is the one that usually gets people really concerned. On the second page, it'll have a list of all the monies that they would like to seek back. And if it's been Medicaid coverage for a period of time, it's going to be it could be a huge amount. I've seen $200,000-$300,000 that the government would like to get paid back through a MERP claim. So 2 letters, they send you in the mail. These need to be responded to. There's responses to them. These aren't things that you need to duck and cover from, but these need to be handled. I've had many family members come in a year later waving these letters around. I'm like, sure wish you'd came in 12 months ago.
Yeah.
All right, so we get our 2 letters. First one comes in. A couple weeks later, hopefully the second one comes in. What's the next step?
Sure. So let's back up to while aunt is alive and talk about how to avoid it. So we do need to respond to the letter, but if aunt has already passed and we're at the point where, kind of is what it is, we don't have any other action, we want to give you some advice that you can take while someone is alive to avoid this Medicaid estate recovery claim. After someone's passed, there are some options. We'll talk about those in just a minute. So you don't, you still do want to go seek out good advice, get some help on what to do. But if you are in a situation where you have a living person receiving Medicaid, there's things you can do now that can really help. And I think important to point out that when people have heard that the nursing home or the state will take your house, this is how this actually takes effect. So if aunt had done no planning and passed away, she may own assets that Texas Medicaid allows her to own, like her house. But if I am a beneficiary of her house, when I go to sell it, the title company will ask if there's a MERP claim. And when they realize there is a MERP claim, you won't be able to sell the house without dealing with the claim.
They will contact the state of Texas. Right. They will find out the amount that is owed, and the title company will ensure the proceeds from the sale satisfy that claim before anything is paid out to remaining family members.
Right, which unfortunately is usually in excess of what the value of the home is.
That's right.
So it's a really kind of rock and a hard place situation for beneficiaries, because great, I've been left this house, but I am going to have to deal with this claim and receive nothing in benefit. Okay. So let's, Chris, tell me some assets. Let's keep using aunt as an example here. Yep. Let's pretend that she, is applying for Medicaid. What are some assets she could still own and be eligible for Medicaid that we would need to make sure and avoid the MERP claim?
Right. So the biggest one you mentioned would be the home. The home and attached property is something that's very easy to own on Texas Medicaid, very easy to keep while on Texas Medicaid, but very easy to lose once your aunt passes away and MERP makes her claim, unless you took the steps that you need to do to protect it. Another asset would be a bank account or bank accounts. You can have some monies while on Texas Medicaid, but you would want those, just like the home, to avoid probate, to go directly to the beneficiaries. We can talk about how to do that in a minute. Sometimes life insurances are an asset you can keep during Texas Medicaid. We've seen people have. And of course, you can have prepaid burial, but that's usually used for the burial. So those are the assets that I can think of just come top of my head. Bank accounts, house, life insurance are all things that, we see people on Medicaid owning, but we want to transition to the next generation without the state of Texas through MERP claiming.
Right. Sometimes what happens is a loved one transitions from the hospital straight to the skilled nursing facility, and if they don't have a lot of cash in their bank account, they may be kind of immediately eligible, so they don't get advice from an elder law attorney like me or Chris. So if the facility helps them submit the application, great, they're eligible, but then there's no good education or information that's passed along about the other things they need to do. So let's go asset by asset.
Okay.
So Aunt has a house.
Yes.
She's eligible for Medicaid, keeps owning the house. Off topic, but going to be a problem for somebody to continue to pay the property taxes, the insurance, utilities, all those things. But nonetheless, Aunt owns a house. How do I protect her house at her death?
Yes, the easiest way, in my opinion, is to do a ladybird deed before the aunt's passing. In other words, she literally has a ladybird deed, which is not a completed gift until death, which is why Medicaid is okay with these being done. You have a completed and signed ladybird deed filed down at the county that says, upon my death, but not until then, this property will pass on to the heirs. It's an enhanced life estate. It's not a regular life estate. It's a ladybird deed. So make sure you're using the right document at the right time. But that will protect that asset from going to probate. It will keep the state of Texas through MERP from recovering against it.
So when can I do a ladybird deed? Do I have to do it early?
You don't have to do it early. No. You just need to do it before death. It needs to be done either by hopefully the principal, as long as they can sign. If not, a power of attorney may, depending upon their powers of attorney, be able to sign it as well. But it needs to be done before the passing. It can be done after they're on Medicaid. It can be definitely done while they're at the facility. It can be done up to that last minute, but it needs to be done before death.
So it doesn't have to be done 5 years in advance.
No, ma'am.
And I'm not moving my house into my kids' names.
Don't give away your things. Do a ladybird deed. That's right. Don't give away your home to your kids. A gifting is problematic. A ladybird deed is not.
Perfect. Asset number 2, I think, was life insurance. What do I do about life insurance?
Yes. The easiest way to handle life insurance is to make sure it has a named beneficiary. What we don't want it to see is no beneficiary or the estate. The estate of aunt is dangerous territory. Medicaid Estate Recovery Program is a federal program administered by the state of Texas. The federal government forces Texas to go through this process. Texas has limited recoveries to probate actions. So things that have beneficiaries, like a life insurance, if it has a named beneficiary, that will leapfrog over probate, avoiding the grasp of Texas Medicaid.
Yeah. And important, I think, to point out that you can't keep all life insurance when you get on Medicaid, but if what you have is either a term policy with no cash value or it has so little cash value that maybe you can exempt it. You can exempt up to $1,500 as funeral costs, and they don't count it. But if your life insurance has cash value, it may be something that you had to deal with to be eligible for Medicaid at the start. So not everybody has life insurance, but if you do, super important to check the beneficiaries on it, which someone could do using their financial power of attorney for aunt.
Absolutely.
Next one was bank account. What do I do about a bank account?
Easy. Either there needs to be co-owners or payable on death beneficiaries. Co-owners or payable on death beneficiaries simply means that upon the passing of aunt and proof of death certificate, most likely, the banks will transfer those assets to the named folks, thereby, once again, skipping or bypassing probate. The key here is skipping probate. You want it to be named individuals, not the estate, not blank.
Yeah. We've told folks before that a retirement or qualified account over the age of 73 is not countable in the state of Texas. What if aunt has an IRA and she's eligible for Medicaid because it doesn't count towards her eligibility? What would I do with that one?
I would want to make sure there's named beneficiaries on the IRA. I want nothing to go back through aunt's estate. Once we've made the decision to seek Texas Medicaid and long-term care, our follow-up goal, is obviously to get Medicaid, but the follow-up goal is to then take advantage of all the exceptions so that the heirs of the family would be able to inherit the assets. And of course, on top of all that, I like to have a will that matches all that, but I want it all to be seamed up. Every asset should have a starting point, a midpoint, and an end point.
Yeah, and a car is another one that you are allowed to have of any value. And the car can transition to whoever the Texas intestacy heirs are, so your kids in equal shares under Texas law, using an affidavit. Now, the kids will have to have the paper title, so you do need to know where the paper title is, but then they can sign to transition that. And let's say that I didn't want all 3 of my kids to get the car, I wanted just one. Texas has a nice new policy that allows you to add a beneficiary on your car title. So you do have to do it during lifetime. You do have to take the paper title down there, sign the beneficiary designation, pay to get a new title, and then get that done now. But it is a neat trick that can allow you to avoid probate, and a car will generally avoid probate as long as you have all the heirs available to sign. So it's not usually one that trips you up, but you do want to make sure and think about it and make sure that it's going to who you want it to go to with no problems as well.
Yep.
Yeah, so Texas is a great state to live in the way that the Medicaid eligibility rules work, but don't forget that very important second step. You have to protect those assets from Medicaid Estate Recovery, or you will be leaving those beneficiaries a big mess.
Yep.
Yeah. So let's say that, Aunt had a niece, and that niece came and talked to an elder law attorney and did all those things. So Aunt has a ladybird deed, has beneficiaries on her life insurance, and her IRA, and a joint owner on her bank account. So when Aunt passes, and I get those 2 letters, what do I do with them?
So we're going to go through them. We're going to respond. We're going to fill them out, and we're simply going to respond with the accurate information that there is no estate. There will be nothing going through probate. All the assets are passing outside of probate, if there are any, and therefore that'll be the end of the claim.
Yeah, it's fantastic. So no claim to make, no assets to make a claim on. You protected the house, the IRA, the life insurance, the bank account. It's magical.
But you responded.
Yes.
You did respond. Okay, Kristen, let's say we did good, but not great. All right. Let's just take the easy ones. Let's say we have our Medicaid for our lovely aunt. She's passed away. The Medicaid has sent us their 2 letters letting us know their intent to file the claim, and they told us the amount. And it turns out that there are assets that did not pass that way.
Right.
Are we out of luck, or is there a next easy building step in our process?
Yeah, I wouldn't say it's an easy building step, but we don't want you to, throw up the towel. We don't want you to quit. You can beat a MERP claim, a Medicaid Estate Recovery claim. There's some obvious and easy exceptions that you start with. So if someone has a surviving spouse, Medicaid waives the claim entirely. Doesn't matter. You could probate a will. They just waive it if you have a surviving spouse, and all you do is submit a death certificate showing that you have that surviving spouse. One other one, which is a little harder to prove, is if the estate is valued less than $10,000. So we've successfully sometimes had a life insurance that came into the estate that was less than $10,000. So Medicaid will waive their claim, basically making a business decision that it's not worth pursuing. One other exception that is fairly commonly used is if there was a unmarried adult child living in the home with Aunt prior to her going to the facility or getting on Medicaid for 1 year, they will waive their claim. Now, that's because they're assuming that that child living there was helping keep her out of the facility, keeping her off of Medicaid. So there are reasons for those exceptions. And then finally, at the end of the day, if you have no exception at all, then there are some timelines that you can, lawyers can help go through and make sure they've met these timelines. And how do those work out? Yeah.
So if this wasn't something where you forgot or couldn't avoid Medicaid Estate Recovery Program, if this is something where we can't take advantage of an exception, surviving spouse, less than 10,000, child living at home, if this is one of those ones that's going to become, I'll just call it more confrontational, there's going to be a probate process. You are going to need to hire an attorney. You are going to need to look at your options, because at the end of the day, even though this is the State of Texas Recovery Program, they are a normal Class 7 creditor which has certain rights and obligations, and an attorney can successfully navigate that process to keep the claim from being perfected and the property be kept safe. That is our, of course, last case scenario. We'd much rather do the easier ones, but it can be done. It just is a process that will take a year, longer.
Certainly can.
Yeah.
Yes, certainly can with some of the timelines. So it is hopefully not a situation where you've listed the house for sale and then are showing up to ask the attorney to help at the time you're trying to get a contract done. It will not be done in time. This is something to hopefully deal with ahead of time. So again, loved one in the nursing home, ding, ding, you need to talk to somebody and see if they were on Medicaid, are on Medicaid, and can still do things. or if they passed away and they were on Medicaid, it really helps to know even going into the probate situation so you can plan that correctly and just be on top of it.
Some folks have, this situation and it's very, very easy because they pre-planned, and other people, unfortunately, were not able to pre-plan, and it can be still successful, just much longer.
Still a scary letter to get.
Yes.
Yeah.
Oh, yes.
Those are some scary calls. I got a letter that says I owe him $230,000.
That's right. That's right. Yeah.
So, yes, it's okay. Either way, it's going to be okay. You should get good information on that MERP claim. You should generally not pay the MERP claim by finding out what your rights are and how to avoid it. But ideally, get that information and do that planning while someone is alive. Makes it much easier.
Yep.
Yeah. Anything else you want to add?
Nope.
Nope. All right. Thanks, guys. See you next time.